Have you ever signed a contract, skimmed the first couple of pages, seen a few words like standard terms and conditions and thought, this will be absolutely fine? If so, unfortunately you're not alone. In fact, I'd say that's exactly what most SME business owners are doing. The commercial deal has already been agreed. Everyone's excited, everyone wants to get going, you've won the client. The salesperson is desperate to get started. The client says, can you just sign this today? And suddenly, there's a 50-page contract sitting in your inbox that you have to deal with. Now, I completely understand why founders don't want to read those contracts. Most of them are dry. Listen, I barely want to read them. They're repetitive. They're full of legal language, it's full of jargon. It looks like it was written in about 1974. But here is the problem with not reading it properly. Those 50 pages will probably govern your relationship with that client for the next 3, 5, or even 10 years. They're going to determine how and when you get paid. They are going to determine a whole host of other things. What happens if something goes wrong? Who owns what you've created for the client? How can either party get out of the relationship if they need to? Whether you can be sued by the client and for how much? What is the limit on your liability? They're incredibly important documents and not to be taken lightly. And yet most people spend more time choosing a coffee machine than they would reviewing the contract that they're about to sign when it's super, super high risk in a lot of situations. So today I thought we'd do something a little bit different. Imagine you've sent me a contract for review, not because you're in trouble, that's not the way we like to do legal here, not because there's already a dispute ongoing, but because you have said to me, Babs, before I sign this, can you have a look, can you review and make sure it's all okay? What actually happens next? So how do we review a commercial contract? What are the key things that we're actually looking for? Where do we spend our time when you engage us? And perhaps most interestingly, what don't we care about? What are the parts that we are actually ignoring? Because I think one of the biggest misconceptions about lawyers is that we sit there and we read every single word from page 1 to page 50 in order. We don't, or at least a lot of us don't. In fact, in reality, if you were sitting beside me in the office and you emailed me a contract right now, you'd probably think I was reviewing it in the completely wrong order. You'd probably be saying that you've looked at clause 1 and then clause 17, that doesn't make sense. But I would open the contract, I'd flick through the first couple of pages, then I'd probably jump straight to page 38, then back to page 12. I'd be following the contract all as it goes around, then off to page 26 I go, then to the schedule at the back of the document. Why do I do it that way? Why does a lawyer do it that way? Because experience tells you where the commercial risk usually lives. And you also have to work out how to trace risk through the document. The first thing I'm interested in isn't actually the legal drafting at all, it's the commercial deal. And I know that sounds really strange because I'm a lawyer, but I don't really care how beautifully drafted a contract is if it doesn't actually reflect what the parties have ultimately agreed, what the commercial position should be. You would be amazed how often I have this conversation with clients. I will say to a client, talk me through the commercial deal. What are the main points that you have agreed with this party? And they'll say, well, we're charging 10 grand a month. I look at the contract, it says 8,500. Okay, well, that's odd, that's not reflective. Then they'll say to me, well, they agreed to pay within 30 days. Well, the contract says 60, so they've just churned out their standard terms and they've not changed anything. Or they'll provide all the information by the 1st of each month. Nothing in the contract says that. So if it doesn't say it in the contract, it's not real. That's just the way it is. Sometimes the legal drafting can be absolutely perfect. It's just documenting the wrong commercial arrangement. It might not be the terms that you've agreed. And if you don't spot that at the beginning, everything else becomes much harder down the line. Because once you've signed it, that contract becomes a starting point for every future conversation. So before I'm even thinking about liability or indemnities or GDPR, I'm asking one specific question. Does this actually reflect the commercial deal that the parties agreed? Once I'm comfortable with that, I'll usually go to payment. Now, you might think that that's because lawyers love money. Well, don't we all? But actually, It's because businesses run on cash flow. One of the biggest mistakes that I see founders make is assuming that because they've agreed a fee, that means that they have fully protected themselves in entering into the commercial relationship. But that's just not necessarily the case. Let's imagine you've agreed a £10,000 or £100,000 project. Fantastic, that sounds like a great piece of work. But then I read the payment clause and it says payment is due 60 days after acceptance. Now we need to find the acceptance clause. We need to find out what acceptance means. The acceptance clause says the client determines whether the services have been accepted. Right, okay, so suddenly you've got an £100,000 project, you've done all the work, you've paid your staff, you've outlaid all the costs, you've paid your suppliers, and yet you're waiting indefinitely for somebody else to decide whether they're happy with the output from the services, and then 60 days you'll get paid after that. That's not a legal issue, that is a commercial issue. So when I'm reviewing payment clauses, I'm going to be asking things like, when are payments permitted to be issued, or when are invoices permitted to be issued? How long does the client have to pay? Can they withhold payment for any reason? Can they offset money that they think you owe them? Can they dispute invoices for months later down the line? Can you suspend the services if they don't pay, or do you have to keep providing knowing you're not getting paid? Can you charge interest if they don't pay? Can you recover debt recovery costs if you have to instruct a debt recovery firm? Because honestly, the businesses I see struggle aren't usually struggling because of obscure legal clauses. They're struggling because money isn't coming in when they expect it to come in. The next clause that I'll nearly always jump to then is termination. This is probably one of my favourite clauses in the whole agreement because it tells me how balanced the relationship between the parties is actually drafted to be. So let's imagine you're entering into a 3-year agreement. That sounds fantastic. You've got that client wedded in for 3 years. That's recurring revenue that you can rely on. That's long-term certainty. That's everybody's happy. Then I read the termination clause. The client can terminate at any time on 30 days notice in what is meant to be a fixed 3-year term, and also you can't. Well, that's not really a 3-year agreement then, is it? And it's more like a 30-day agreement and only one that they can trigger the end of. That's a huge difference. Another thing I'm looking for is whether termination is linked to breach. So if someone breaches a contract, how long do they have to actually fix that breach? Can they fix that breach? Does every breach allow the other party to terminate the agreement? Or is it only material breaches? These are really, really important points. What is a material breach? What constitutes a material breach? Because if those provisions aren't clear in the document, it creates uncertainty. I also want to know what happens after termination. So does the client still have to pay their outstanding invoices? Well, I would hope so. Who owns the work that's already been completed? What if you've only been part paid? Does all IP transfer? Do confidential obligations continue? Do intellectual property licenses end immediately? What has to be returned? What has to be deleted? Sometimes I spend more time on what happens when a contract ends than how it starts, because that is usually where we can see a lot of significant disputes happening. Now, let's move on to one of the clauses that everybody talks about, liability, the big one. So whenever clients send me contracts, they nearly always say, can you just check the liability clause over? Yeah, absolutely I can. But here's something that most people don't realise when they ask me to do that. The liability clause will rarely exist in isolation. So imagine the contract says your liability is capped at 50k. Wonderful. You can only be on the hook for 50k if something goes wrong. Everyone breathes a sigh of relief. Then 20 pages later, there's an indemnity. And that indemnity says you'll indemnify the client against all third-party claims arising from certain matters. But there's no cap on the indemnity, it's specifically carved out. Suddenly, your 50k liability cap doesn't look quite so comforting because it's not covering your highest risks. This is why contract reviews aren't just about looking at clauses individually, it's about understanding how those clauses interact with each other. Does one clause really undo the other? That's something I spend a lot of time thinking about when I'm reviewing a contract. And while we're on the topic of liability, I will always ask clients the same question. What's the worst thing that could realistically happen here? Not theoretically, but realistically from a practical perspective. Because if you're providing strategic advice, the risks are very different from manufacturing medical equipment. If you're building software, the risks are very different again. The contract should reflect the commercial reality of the business. It should not simply copy and paste wording from another agreement. Then we come to one of the clauses that I think is consistently underestimated, the scope clause. What is actually included in what you're providing? Honestly, I think this is probably in the top 3 most important clauses in any commercial agreement. Now, me and all lawyers will argue about that, but that's just my opinion. Why? Because every single dispute, in my opinion, starts with expectations. One party thinks they agreed X, the other party thinks they agreed Y. If the scope is 100% crystal clear, then most of those arguments can actually just disappear. If it's vague, you've got problems that you need to deal with. I often see scope clauses saying things like, the consultant will provide strategic support to the client. Well, what does that actually mean? Strategic support for how many hours? How often? By telephone? Is it by email? At the client's offices? Is it unlimited revisions? Is it unlimited meetings? There's a world of difference between 10 hours a month and unlimited access. But I've seen both of these described as strategic support. One of my favourite questions to ask clients is this. If somebody else joined your business tomorrow and they picked up the contract, could they read the scope and know exactly what you're expected to deliver? If the answer is no, the scope probably is not clear enough and needs to be revisited, because clarity protects both parties. The client knows what they're buying. You know what you're delivering. And perhaps most importantly, you know what you are not delivering. Because scope creep is one of the biggest profit killers in business. It never arrives dramatically. It never comes in flying its flag. Nobody phones and says to you, we'd like an additional £30 worth of work, please, for free, that you never originally quoted for. Instead, it's an extra meeting or an additional report or a quick review. We get that one all the time. Or a small amendment or another workshop or another call. And before you know it, you have doubled the amount of work you're doing without changing the fee. That's why a good scope isn't restrictive, but it is protective, and it's protective for both sides. The next place I would usually then go after that is intellectual property. Now, this is one of those clauses that founders often think just doesn't apply to them. They might just skim over it. They'll say, well, we're not a software business, or we're not inventing anything unique, so it doesn't really matter. But intellectual property is much broader than people often will realise at the start. Let's say you are a marketing agency. Who owns the campaign you've created? You're a consultant. Who owns your templates? Who owns your output, your report? You're a training provider. Who owns your course materials? You're a software company. Who owns the source code? That's a biggie. Or if you're an architect, who owns the drawings that you have created? And importantly, who owns all these things if the client hasn't paid? Almost every business creates intellectual property in one form or another. The question is whether you are accidentally giving it away. I've seen contracts that effectively say anything created during the engagement belongs entirely to the client. Now, sometimes that is perfectly reasonable. If you're being paid to develop bespoke software for one client, then perhaps they should own it and they're probably paying that price tag. But what if you've used your own frameworks, and what if you've used your own know-how and your own methodology in creating the software? What if you've spent 10 years refining a process and now one contract accidentally gives ownership of it to a client? I've seen it. I've seen it shut down a business. That's a very different conversation. What I'm usually trying to achieve in a contract is making sure the client receives exactly what they paid for without my client as the supplier accidentally giving away the foundations of their own business. I have seen it. There's often a perfectly sensible compromise. The client owns the bespoke deliverables. My client, the supplier retains ownership of their underlying IP and grants a license for the client to use that. Everybody wins. The next clause that I'll always spend a lot of time, and probably time arguing, but also looking at, is indemnities. Now, indemnities have a habit of frightening people because lawyers often talk about them as though they're this mysterious and convoluted thing. They're really not, although the wording often can be. Think of an indemnity as someone saying, if this specific thing happens, I'll pick up the bill, I'll compensate you. Now that's a very powerful promise. The question is whether it is a sensible promise for you to make. Let's imagine that you are providing software to your client. The contract says that you'll indemnify the client for any intellectual property infringement. Okay, can you actually stand behind that? Have you or the company written all the code? Are you using open source software? Are there any third-party integrations involved? What if somebody else has infringed somebody else's copyright without your knowledge? What if a contractor developed it for you and they haven't assigned it to your business? You need to understand exactly what you're promising. The same applies to data. Sometimes I'll see an indemnity that effectively says if there's any data breach whatsoever, the supplier will indemnify the customer against every loss. Really? Any breach. Any breach whatsoever. Even if the customer caused the breach. Even if it arose because one of their employees emailed passwords around the office. That's what that would cover. Those are the sort of conversations that we're having all the time. Not because we're trying to remove every indemnity. They should be in there for high risk situations. But because we're trying to make sure that the risk sits with the party that's best able to control it. After that, I'll usually move on to the data protection clause. Now, I know, this is the moment somebody says GDPR and people switch off. But here's why I think it's becoming much more interesting over the last few years. Businesses are collecting far more data than they used to. AI in particular is changing how information is processed. I know we're all sick of hearing about it, but it's true. Software platforms are becoming much more sophisticated. Marketing is more data-driven than ever before, so data clauses matter. One of the first questions I'll ask when it comes to data in a contract is who is actually the controller under GDPR? So who is deciding why the data is being processed? Who's simply processing it on somebody else's behalf, on someone else's instructions? Because people often use those words interchangeably. Legally, though, they mean very, very different things. Then I'll look at the practical obligations of the clause. So are you agreeing to security standards that you don't currently meet? Does the contract require ISO accreditation but you don't have it? Is there annual penetration testing, encryption standards, specific response times? Can you realistically comply? Because there is absolutely no point in signing a beautifully drafted clause if your business can't actually deliver it. Then I'll move on to the warranties section. This is another clause where wording really matters. Let's imagine you are providing consultancy services to a client. One contract says you'll use reasonable skill and care. Another says you'll guarantee specific outcomes. Those are two very different promises. Nobody can guarantee every commercial outcome. Markets change, customers change, circumstances change. What we can usually promise is that we'll deliver our services competently and professionally as the market would expect. So whenever I see warranties, I'm asking, are we promising something that we can actually control? Because if not, we're introducing unnecessary risk. The next thing I usually look at is exclusivity. This one catches businesses by surprise. Sometimes buried halfway through a contract will be a sentence saying that the supplier can't work for any competitors, or the client has exclusive rights within a particular sector. Now, occasionally that is commercially justified, but very often it isn't. Imagine you're a marketing agency, you sign one client, suddenly you've agreed not to work with anyone else in that industry for years. That might sound manageable today, that might be a big fish client and you're really happy to land them, until 6 months later when another fantastic opportunity comes along because your business is growing and doing really well, and you realise you've contractually ruled yourself out of applying for that opportunity. Again, it's not necessarily wrong, it just needs to be a conscious commercial decision, not agreed to willy-nilly without thinking it through properly. One thing you'll probably have noticed by now is that I keep using the word commercial. That's because I genuinely believe that contract reviews aren't just legal exercises, they're commercial exercises documented legally. If I simply told you what the law said, I don't think I'd be doing my job properly, and neither would any of my team. My job is to help you understand what you're actually agreeing to from a business perspective, and does it reflect what you think you have agreed to when talking to the other person? Because ultimately, that is what matters. Now let's talk about one section that most clients never read. The boilerplate clauses. Honestly, people's eyes totally glaze over at this point. I get it. It's your entire agreement clause, assignment, waiver, third-party rights, force majeure, notices, governing law, jurisdiction. People think they're all really standard. Some of them are, a lot of them are, some of them really aren't. So take assignment. Can your client transfer the agreement to another group company without asking? Can they sell their business and automatically transfer your contract across, or do you need consent? Can you do the same? Those answers really matter. Or governing law, like if you're an English business and suddenly discover you've agreed that disputes will be governed by New York law, that's quite a significant discovery if you have to traipse off to court and deal with New York law if there's an issue. So while these clauses may seem boring, they're often the ones that are secretly shaping what happens if things ever go wrong with the commercial arrangement. Now here's something people often ask me. They'll say, Babs, do you negotiate every single point in a contract? Absolutely not. It's actually one of our selling points. I actually think one of the biggest mistakes that less experienced lawyers can sometimes make, not every clause deserves a battle. Every negotiation has a cost. There's the time cost, there's legal fees, and importantly and often overlooked is relationship capital and commercial momentum. Sometimes a clause creates so little practical risk, it's simply not worth spending 3 weeks arguing over it. Instead, I would ask myself 3 main questions. Firstly, how likely is this issue ever to arise? Secondly, if it does arise, how serious would the consequences actually be? And thirdly, is this something that my client can live with from a commercial perspective? If the answer is yes, fine, let's move on. Who cares? Because contracts are not about creating perfection. Trust me, if you're seeking perfection, it won't happen. But they are about creating clarity and certainty. And I think that's something that founders often appreciate. When clients instruct us, they're not asking us to win points for the sake of point scoring. They're asking us to protect their business while still getting the deal done. Because nobody benefits if lawyers spend 6 months negotiating clauses that will never ever matter and never come to anything. One of the things we often say internally at Jamieson Law is that our job isn't to produce the longest markup, it's to produce the smartest and the most efficient one that protects our client. If there are 3 clauses that genuinely expose our client to unnecessary risk, we will absolutely push back on those 3 clauses. If there are 20 amendments that make no meaningful commercial difference, we're probably not going to spend your money arguing about them. That is one of the reasons that we describe ourselves as commercially focused lawyers, as your commercial partner. We're always trying to balance the legal protection with the commercial reality. Because the best contract is not the one that's weighted entirely in your favour, as strange as it may seem. The best contract is one that both parties are comfortable signing because they understand it, it reflects the commercial deal, and it gives everyone certainty about what's expected. If I could leave you with one piece of advice after today's episode, it would be this. Don't think of contracts as something that you just sign and file away and it's done. Think of them as operating manuals for your commercial relationships. If a disagreement arises 6 months from now, a year from now, this is the document that will be the first thing that everyone turns to. If you go to take legal advice, your lawyer will ask to see this before they say anything. So make sure it reflects what you actually intended. Make sure it is commercially sensible. And make sure you've understood before you sign it. Because the best time to negotiate a contract is before there's a problem, not after there's one and everything's already signed. I hope you've enjoyed this slightly different episode today. If you have, I'd love to know, because I really enjoy doing more of these where we actually take you behind the scenes of what we do every single day as commercial and corporate lawyers. Perhaps next time we could walk through a shareholders agreement, acquisition agreement, or even a commercial lease in exactly the same way. If that's something that you think you'd find useful, please let me know in the comments or drop me a message. I'd be delighted to do that. And if you know another founder who signs contracts every week but has never really thought about what's inside the detail of them, I'd be incredibly grateful if you shared this episode with them. Until next time, thanks so much for listening everyone, and I will see you on the next episode.